All right, everybody, now we need to talk about commercial general liability. And this is a really big topic. There's probably 100 pages in the book dedicated to liability. It might only be 75, but it's a lot. And again, we're going to abbreviate this as CGL. So when you hear people in the industry talk about the CGL, they're talking about commercial general liability. Up to this point, it's mostly been property coverage that we've been talking about, and then the indirect losses that are caused by loss of use of that property when we talked about the business income coverage. Now we've got to talk about what if we damage somebody else? So somebody else gets hurt, or through our actions, somebody else claims we've damaged their property. This is where your liability coverage is going to help you out. And every business needs liability coverage. Really doesn't matter what you do. You're going to need liability coverage. If you have if you've got a premises, you need liability coverage because somebody could get hurt on the premises. And that's real simple. About a third of liability claims are just slip and fall. Somebody got hurt on the property, and you might not literally have been negligent. Generally, if somebody gets hurt on your property, you're probably going to be held liable anyway. It's going to be hard to argue that that should be all their responsibility. Here's the thing about liability in terms of the nature of the risk. It's the kind of thing that keeps business owners up at night because these are not predictable. These losses can come from anywhere. Anybody can sue you for any reason at any time for any amount. There is no upper limit. And so there is potentially a much more expensive exposure with liability than there is with property, right? I mean, worst case scenario, at least I can imagine that with property. I could say, all right, yeah, we've had the whole building and everything in it was destroyed. And I can value that and say, all right, if I buy insurance in that amount, I'll be covered. You cannot predict what somebody's going to sue you for. It's just not possible. So that creates a much bigger headache for people who are trying to manage risks on behalf of organizations. And I think we've talked about that before. One nice thing about liability coverage, your defense costs are usually included above limits. There's a couple exceptions to that we'll talk about, but normally you'll have a limit of liability coverage. Let's say it's $1 million. It will cost money to defend if somebody accuses you of negligence. If they file a lawsuit, there's a process that you have to engage with, and that's going to be expensive. You need lawyers to do that for you. And they are highly skilled people, and they don't work cheap. So the cost of defense is a fairly expensive thing. The good news is if you have an insurance policy, they have all their retained lawyers on staff. And that's what they do, is all they do is defend lawsuits against their insureds. So they've covered that as a fixed cost. And so they can allow that coverage to be part of your policy above the limit. So if you had $1 million limit, we generally don't take cost of defense away from that when we're settling claims. One of the problems that you have is once you've been sued, there's probably some actions that you're going to take to try to prevent that likelihood in the future. So if somebody slips and falls, you are probably going to figure out a way that that doesn't happen in the future. Maybe you change the flooring somehow to make it less likely that somebody would slip and fall. Well, all of those costs, that's not covered by insurance. Those are loss control costs, and they might be worth doing. And a lot of times that's when they get done, is when people realize, wow, it would have been really helpful had we done this earlier. So those costs to prevent future similar losses, you're not going to get coverage for that. The other thing that you can't get coverage for is reputational loss. So lawsuits sometimes get a whole bunch of negative publicity, and you can't really do anything about that as a business owner. The best example I have of that comes from, about 15 years ago now. And if I tell you, I'm going to tell you a story about somebody finding a finger in the chili at Wendy's. You probably remember this story. So yeah, a woman was eating chili at Wendy's and claimed she found a severed human finger in there. Little gross, not surprisingly. Yeah, she filed a lawsuit. I would not blame anybody for doing that. Makes sense. Turned out she made the whole thing up. Wendy's, they did the right thing right away. They asked for an inventory of everybody's fingers in the that was in the supply chain. to make sure that nobody had lost a finger in the process of preparing what the ingredients for their chili. And they couldn't come up with anything. I always said, no, nobody's lost a finger. We're all good here. And a little bit more investigation turned out the woman had a friend who'd lost a finger in an accident a long time ago and kept it for some reason, and then let her borrow it so she could put it in food and pretend that she'd been, the victim of some horrific, disgusting experience. To this day, chili sales in California from Wendy's are down about 30%. So even though it wasn't true, even though it's completely fabricated, there are still legitimate costs that were borne by the business in that case. And sure, you can sue the person who did that to you, but the odds that they're going to have the money to, compensate you for the harm that they've done to your business, if somebody's going to pull a stunt like that, I'm pretty sure they're not independently wealthy, and they could afford to pay out of pocket the millions of dollars in lost revenue that could legitimately be claimed by a business. Point being that, whatever negative damage is out there, you're going to experience that. And it's bad enough when it's real. But even if it's false, you're going to experience those reputational costs, and there is no insurance product that will help you with that. So liability has a whole bunch of problems for us that we have to consider when we think about that. Okay, so here's the thing. What triggers coverage is the idea of legal liability, and that means that a court has to judge that you are legally liable, and it will be either a judge or a jury that investigates the lawsuit to come up with a decision whether or not you're legally liable. Sometimes the insurance company will do its own investigation and say, look, we're pretty sure our insured is going to be legally liable, and we just move straight to settlement, so we don't pay any money to go through a court process finding our insured responsible, because we think our insured is going to be responsible. So when that happens, we can kind of shortcut the process and just focus on how do we appropriately compensate the injured party. But without the insurance company deciding that, we're going to expect a judge or a jury to make that decision. And without that, we're not going to pay. So what that means is that even if you're not found legally liable, you have to go through that process, and it involves lawyers and it's expensive. And so then we get to this third point here, and that's what we're saying. The insurance company will do its own investigation. They may decide, hey, it's going to be cheaper to settle this lawsuit than it is to fight it, because we already believe our insured is responsible. So there's no need to have a court battle. And so we'll go ahead and settle. Here's the thing. Sometimes the insured gets upset about that process. Sometimes the insured says, look, this person who's suing, I don't think they're entitled to anything. I would prefer that you not pay them anything. Tough rocks. We don't care what the insured thinks. If you have insurance coverage, it's up to the insurance company to decide whether or not they're better off settling. Their job is to minimize the total costs that they have to pay. They're not necessarily minimizing the amount that is attributable to you. That's not really the goal. Once it's in their hands, they have the right to decide whether or not they're going to settle. And sometimes the insured gets upset about that. But if you want coverage to apply, you have to rely on the judgment of the insurance company, who has seen, thousands of these cases, where most of the time you've only seen one. And so things that don't seem fair or logical to you might make sense to the insurance company, and they've got more experience with that, so they're going to be able to be the ones to decide whether or not settlement happens. So that's important to know. The insurance company decides whether or not they settle, not the insured. They're not going to ask your opinion on that strategy. Okay. When we talk about lawsuits, we're talking about civil law. It's generally not criminal law where we have lawsuits. Crimes are wrongs against society, and the way you can tell something is a crime is if the penalty can include imprisonment. Your freedom can be taken from you. Where we're going to spend all our time is in the civil system, where it's between two parties. And that's a separate court system from the criminal system. Although it is possible that a single action could be both a crime and a civil wrong. An example might be something like assault. You hurt somebody else, that's a crime, but you also damage them, and they can seek damages against you. That would be an act that's both a crime and a civil wrong. That's an individual act, not really a corporate act. Where we talk about where can legal liability come from? What does a company have to worry about? It comes from three places. It comes from torts, comes from breaches of contract, and it comes from statutes. So I wanted to come through those real quick. So we got different categories of torts. I'm going to save those for the next slide. When we talk about breach of contract, that's a little bit more straightforward. We had a contract and one of the parties didn't live up to it. So there could be consequences for that. If you signed a contract and you didn't fulfill your part of the deal, the other party can pursue legal action against you. And sometimes the remedy is we force you to do what you said you were going to do. More commonly, the remedy is damages. Your failure to do something costs the other party money, and you're going to have to compensate them. Statutes. Sometimes there are laws that require you to do certain things as a company. We'll talk more about workers' compensation later. That's a good example. Workers' compensation liability comes from statute. So it's not about negligence. Most torts are related to negligence, and we'll talk about this in just a second. But some of it comes from statutes, and that's actually a strict liability statute that says if somebody gets hurt on the job, as an employer, that's your responsibility, even if you were not negligent. So we don't care. We don't look at the circumstances. We just say, no, this employee got hurt on the job. Employer, that is your responsibility to pay for it. And the reason that we ended up doing it that way is because it's more efficient than trying to force the worker to file a lawsuit to determine if there's negligence or not on behalf of the employer. Not to mention all the morale problems you have with that. Employers ultimately decided they were better off with mandatory workers' compensation coverage to help employees when they get hurt on the job. And then the trade-off is that is the only remedy that is available to the employee who's been hurt. They get what they can get through the workers' compensation system, and that's it. They don't get to sue for additional damages in most cases. That was the theory behind workers' compensation and why employers would prefer that. In reality, of course, there's always exceptions. So we'll talk about some of that when we get to workers' compensation coverage later in this unit. So 3 places where you can have torts. One, we already mentioned the idea of strict liability, and we've mentioned this before. Workers' comp is strict liability, so is product manufacturing. So if you are a company that makes products, if somebody gets hurt, doesn't matter, they are automatically going to be able to recover from you. You are responsible. The circumstances don't matter. That's why we have all these crazy product warning labels that we might have talked about before, like especially on a ladder, right? Do not stand above this step. They're trying to do whatever they can to make sure that people don't do that because they know if they get hurt, they're responsible. And there's a limit of what you can do. You can paper your products with warnings in the hope that's loss control, that's loss prevention. We're hoping for that because product manufacturing is a strict liability. So if you make a product, somebody gets hurt, circumstances don't matter, you're responsible. That's what we have to do. Intentional torts. Sometimes it happens where a person should have been able to foresee a harmful result. I don't know, an employee of yours is doing work on somebody's house and the homeowner gets into an argument with them, and so they deliberately set up an appliance to malfunction and it causes a fire at their house. Well, if they did it on purpose, that's an intentional tort. We're going to find out intentional stuff is excluded. And that's always the case with insurance. Intentional acts are always excluded. And so the issue is going to be, should you have been able to foresee a harmful result? That's kind of the standard that we go by. Most of the time when we deal with liability, we're dealing with negligence. The idea that you failed to perform a duty and it resulted in somebody getting hurt. So we actually have 4 elements. This goes back to 270. You got 4 elements of negligence. You have to have a legal duty to protect somebody. You have to fail to perform that duty. It has to result in damages to the person. And then proximate cause. Your failure to perform the duty is what actually led to the problem. So my employee drives a vehicle. They have to follow the rules of the road. They fail to stop at a stop sign. They run into somebody else and they wreck their car. Okay, pretty straightforward. The liability there is clear. You've got all 4 of those elements there. Sometimes it gets a little tricky. The story I tell in 270 is about a hibachi restaurant that liked to fling food and try to get the customers to catch it in their mouths, right? Hibachi, they're grilling in front of you. So they're chopping it up and they're throwing food to their customers. Just kind of a neat little thing. It's just something that they do. Well, one time they did this too. This was a restaurant that happened to be in Seattle. They threw a piece of food to an elderly gentleman, and he tried to duck to get out of the way, and he ended up wrenching his neck so badly that he had to get an operation. And during that operation, he had an adverse reaction to anesthesia and he died. And so when his family sued, not only did they sue the medical providers, as you would expect, they sued the restaurant saying, look, restaurant, if you hadn't been throwing food at him to begin with, this never would have happened. And so the issue that the jury had to decide there was proximate cause. Was the throwing of the food what led to this guy's death or not? And I mean, there's no, it's up to a jury. And so they'll hear all the facts of the case. But the truth is, I could pick 2 groups of 12 from this class, and they could debate this and come up with 2 different results. There is no hard and fast science about, am I going to be found liable? People don't like uncertainty. They want to know, well, if this happens, will I be liable? The truth is, hey, tell me what the judge or the jury is going to say. And even a lawyer is going to give you their best shot, but even they have to be real careful and say, look, I can't guarantee anything. And then so they leave the decision up to you. Do you want to, is that something that you want to contest in court or not? Now, if it's an insurance situation, the insurer will make that decision. So in that case, the restaurant settled. So that means they paid something. But most of the time when you have a settlement agreement, there's confidentiality and people aren't allowed to talk about amounts. So it's kind of unsatisfying. You never really find out what happened. But I do know that if there's a settlement, that means they paid something and they paid more than they wanted to. But it also means that they paid less than what the family was seeking. So somewhere they negotiated that, and you just don't know how that ended up. But that's a negligence case there. In commercial insurance, there's 4 places where loss exposures for liability come from. Premises liability, somebody gets hurt on my premises. Operations liability, in the course of me doing my business, we end up damaging somebody, either bodily injury or property damage. Products liability exposure, if I make or sell products. So retailers and more commonly manufacturers need product liability exposure. And then completed operations liability. So, okay, we repair appliances, we go out, we fix somebody's stove, and we end up with a problem where it doesn't work correctly and it burns down their house. That's completed operations liability. So those are the 4 places where this can come into play. So as an overview, the way this actually works, okay, remember, we're trying to put together a package for a business. If I'm a broker, that's what I'm trying to do. So what I can do is, for the liability piece, there's an ISO form I can use. Insurance Services Office makes a standard form, and then I can use that in combination with declarations. So showing, well, which premises are covered, which operations are covered, and then that creates my CGL. Coverage part. And then I can package that with property coverage. I can package that with business income coverage. I could package that with equipment breakdown, all these different lines that we've talked about. That could be part of the package. Or maybe the insurer I'm representing only wants to sell liability. And so it won't be part of a package. It'll just be one line of coverage for my client. We could do it that way, monoline, right? That's what that means, one line of coverage. So most of the time it's economical to be able to combine coverages, not always. So for example, our company, our propane company, we had specialized propane liability. You can't get that with a CGL. It's special. So that was a separate line that we purchased separately, and we needed a broker to help us find that. There's not that many people that write propane liability coverage. And so for that line, for us, that was always mono line, and the liability came somewhere else. And then the auto coverage came along with business property. We had a package for our other exposures. We've talked before about occurrence and claims made, right? And so when we're talking about, is this covered under this policy or not, Well, we have two different forms. One is occurrence, meaning that it has to occur during the period of time that we provided coverage. And then claims made says, well, you have to actually make a claim. Occurrence is way more common, by the way. But claims made, where you can have a problem is if you move from claims made to occurrence coverage, right? Let's say I had a claims made form and for some reason I switched to an occurrence form. All right, well, now I'm in a position where I might find out that I had claims made coverage, something happened, but I didn't make a claim because I didn't know. Well, that can be a problem. The reason that occurrence is most common is because people can sue you. Most of the time, if something happens today, they're not going to sue you tomorrow. A lot of times they have a couple years to think about actually formally filing a lawsuit. And so the occurrence coverage tends to be a little bit more attractive. All right, so as an overview, the way things work, the bulk of the coverage comes from coverage A, bodily injury, property damage. When you think about companies being liable for something, most of it is there. Coverage B is extremely specific, personal and advertising injury. We'll talk about those kinds of losses and what they look like. Then we have coverage C, which is just medical payments. The key with coverage C, we don't concern ourselves with legal liability, and because of that, these are going to be relatively small claims. So coverage C might have a $10,000 limit. $10,000 is a lot of money, but in terms of a liability loss, it isn't. So we'll have a much smaller amount of coverage C. The bulk of what we're trying to protect ourselves against comes from coverage A. Okay, that's a good place to take a pause in our lecture here, and we'll break it up and we'll get another one in just a little bit. Thanks, guys.